SJC-12610, Commonwealth v. Zachariah J. Larose.
Mr. Rangovy, good morning.
Good morning, Mr. Chief Justice, and may it please the court. David Rangovy is for Zachariah Larose. This case is here on further appellate review from an order of the Eastern Hampshire District Court granting the defendant's motion to suppress. In granting that motion, the judge recognized that a single brief crossing of the fog line or the edge line does not violate the marked lane statute if, in the judge's words, there's no indication in the record that that crossing is unsafe. That ruling should be affirmed. The legislature simply could not have intended Massachusetts drivers to be subject to traffic stops for the sort of commonplace de minimis imperfections that are committed by almost every car on the road.
All right, so I'm driving down the highway
Yes, sir.
and I go 56 miles an hour. Can the police pull me over?
Yes, Your Honor. That's because the speeding statute makes that a prima facie violation of the statute, and the officer can pull that person over. But there is a difference in this statute. This statute.
So in that case, is this, you know, and we would hope that wouldn't happen, and we would hope it would be done
Right.
for impermissible racist issues, which you allude to.
Yes, sir.
As well. But what I'm wondering is, if we have this component that you ask us to draw, because the legislature has said, here are the rules of the road, and we assume that they're enforced, and hopefully they're enforced in a non-discriminatory manner. But I'm not getting your argument that we have to impose in this rule of the road a different component. Can you address that, please?
Yes. All I'm asking the court to do is to read Section 4A by its plain terms. And its plain terms are quite different from the speeding statute. The speeding statute, I think, is equally clear that there is a safety component on the back end of the speeding statute, but it does say quite clearly that it's a prima facie violation of the speeding statute to go over the posted limit.
But what if I'm a bicyclist? That was the last case we just heard, right? And I'm riding my bike on the fog lane. I would hope that people don't come near me.
Yes, Your Honor. And I think if a car did deviate over the fog line when there was a bicyclist there and came close to that bicyclist, that would be the exact sort of deviation that I would submit as a violation of the statute. But I would submit that there does need to be some sort of safety component, the main one being that if you read this statute, Section 4A, it's a single sentence with the two clauses that we're really talking about here, separated by a conjunction. And I don't see how we can kind of read that conjunction in the disjunctive and say that those two clauses, and that is how the Commonwealth reads the statute.
Really? When any way has been divided into lanes, comma, the driver of the vehicle shall so drive that the vehicle shall be entirely within a single lane, comma.
That's right. And in footnote 9 of my brief, I've cited.
And he shall not move from the lane in which he is driving until he has first ascertained if such movement can be made with safety. Doesn't seem like, it seems like you can clearly separate that into two components.
I think you could. I just don't think that's the most reasonable reading of the statute. When this court has repeatedly said that punctuation is probably the least important component of statutory interpretation, and also repeatedly said that and is generally always given the conjunctive reading unless it would almost be nonsensical to give it the conjunctive and then you read it disjunctively.
So your argument is purely a statutory interpretation argument?
That's the thrust of my argument, yes. I mean, I think some of the other...
You have a lot of...
I have a couple of allusions.
Important stuff in your brief.
Yes.
About the ramifications of our decision.
That's right, and I think...
But what you really are saying is we should read the statute.
Yeah, I think what I'm really saying is the statute I would submit is ambiguous. And when the statute is ambiguous, you look to legislative intent. And I think it's instructive to look at the legislative intent to know what the consequences would be of one reading of the statute versus another.
Let me understand your reading better then, because what I'm reading is that you can't move over until you, the driver, first ascertain that it's safe to do so.
Yes, Your Honor. My reading is that those two clauses are basically should be read together. And you have an obligation to drive entirely within your lane, and you can deviate from your lane when it's safe to do so. And so those can't be severed from one another. They have to be read as one whole.
So I think that's a reasonable reading. But if the police officer thinks, well, he didn't move over there because he thought it was safe to do so, but he drifted over there, then why wouldn't that be violative of the statute?
Well, I think that's just an incredibly difficult inquiry for the officer to do, to try to get into someone's head.
That's a fair point. But I mean, if you could interpret the statute, I mean, I think I might be reading it the way you do. And I'm thinking, well, the officer could say, gee, I think that that person's going 56 miles an hour. I'm just going to be a jerk and pull them over. Oh, I think he didn't move over there after ascertaining that it was safe to do so. I think he drifted over the fog line once. I'm just going to be very unfortunately making a decision based on that minor thing, which is a concern for all the reasons you say.
Yes.
Well, it's a big concern for all the reasons that you say. But why isn't it just like Justice Gaziano's 56-mile-an-hour point?
Well, I think my point is, I think the only way to determine whether a driver ascertained if a movement could be made with safety is to actually assess whether that movement is safe or not. I think we want officers not trying to get into a driver's head and see whether something was intentional or inadvertent, but we want them trying to see whether something was safe or not.
As I read it, it seems that the statute's giving permission to pull over if you need to pull over and cross the fog line. But if you're just drifting over, it's different. It's clear to it should be clear, or could be clear, that the person's not checking. It's a drift. They're not paying attention to something.
Well, I think even if we look at the facts of this case, I think that there could easily be a measure of ascertainment that's conducted by Mr. Larose. I don't think it's a coincidence that the only time he deviates is basically the only time when it would be safe to do so. When there's an intersection, when there are cars on the left, when there are mailboxes on the right and a guardrail on the right, he's perfectly within his lane.
So he's saying, let me check so I can drift.
Well, I think he's at a point where he hasn't passed a car for 17 seconds. He sees no cars coming, which would ultimately be in the next 3 minutes.
So it's an intentional drift, though.
Well, I think at that point he's ascertained that the road is completely wide open, and that he doesn't need to white knuckle, stay in his lane perfectly for every moment. And I think there's also an added component of he's been followed by an officer for 40 seconds at that point. People get nervous.
Does your rule apply to crossing the double yellow line too? That as long as it's safe to cross the double yellow, you can go over there and drive on the other side of the road whenever you feel like, as long as there's no one around?
I think that's a point the Commonwealth makes in its brief. I don't.
But your rule, it says, your rule is we got to build safety into any lane crossing's fine as long as it's not unsafe, right?
Right, so my point is, something like that, I don't know if it would be a violation of this statute, but if someone is unable to maintain their lane of travel or staying in one lane for an extended period of time or deviating or swerving multiple times over the lane lines, that could give rise to a potential inference of impairment, a potential violation of the negligent driving statute. So there are other statutes that deal with that slippery slope.
Doesn't that inform the first clause? When any way has been divided into lanes, drive the lane shall so drive that shall be entirely within a single lane. Doesn't that suggest that we want people to stay in their lane?
Well, the point I made, I think, at page 8 of my brief is that I think what that suggests by applying only to multi-lane roadways is that the point of the statute is actually to avoid deviations from one lane of travel into another lane of travel. So I think, for example, the State Supreme Court in Idaho, State Supreme Court in Montana, they've both read their analogous statutes to basically say that it doesn't violate to go over the fog line because you haven't gone into another lane of travel. And that initial clause limiting the application of Section 4A to any way that's been divided into lanes suggests as a matter of legislative intent that the point is to keep cars from going from one lane of travel into another lane of travel. So that would be a situation that would distinguish your hypothetical from my case.
And I watched the video as well, and we have these rural, windy roads, and that's where people walk their dogs and run and bicycle. Wouldn't it be reasonable for the legislature to say, which they probably want us to do, to stay in your lane, to always to stay away from people who could be on the side of the road.
Yeah, I do think that's reasonable. I guess my point, as I said earlier in response to your question, I think the statute is ambiguous, and at that point, one measure of legislative intent, I think, is looking at the third clause of this statute.
Right, because clearly, it'd be like, if you're pulling over to go to the 7-Eleven, you're going to cross the flag line. If you're pulling into your street, you can cross the double yellow, the
Right.
flag line.
This is something that all cars are doing at all times, all throughout their driving conduct. Since I've been assigned this case, I mean, you're looking for it, and it's really everywhere. People are crossing the lane lines and the fog lines. It's happening inadvertently, intentionally. But I think this is another key point that I think is really important, is that I don't see a way for the Commonwealth to avoid the absurdity point that I made in my brief, that if Clause 2 truly stands alone, if you can never deviate unless you're changing lanes, then there's no textual
get
way.
home.
I'm sorry?
Then you can't go home.
Then you can't go home. Then you can't go around a dead deer and then go back into your lane. You can't go around a tree branch and go back into your lane.
But if your view is you could drive half in the lane and half out of the lane,
No,
if we
no.
want to talk to about absurdities, right?
Not exactly, because I think at that point, as I said, if someone's unable to maintain their lane of travel, that could be negligent driving or a potential inference of impairment.
But doesn't
but why-
drifting suggest somebody's not paying attention?
Well, Your Honor, I don't.
Different than a deliberate turn to cross something or avoid something.
Well, I would point to kind of the language from the Supreme Court of Florida in Crooks. There's no objective indication on the evidence here that Mr. Crooks in that case, Mr. Larose in this case, failed to ascertain that his movements could be made with safety. So I don't know how we get into a person's head other than to say, was it safe or was it not safe? And the finding here by the judge that hasn't been challenged is that there's no indication in this record that crossing was in any way unsafe. And I think that's really, we want officers looking for safety violations, not trying to figure out, did that look inadvertent or did that look intentional? Especially when we see Mr. Larose is followed after this deviation for 20 more seconds. And at that point, the officer could maybe have his hackles up and say, he deviated, I'm going to keep watching him. And there's nothing. He still drives flawlessly for the next 20 seconds. So we have 40 seconds of perfect driving conduct, a 2 to 3 second deviation, and then 20 more seconds thereafter. I just don't think that's a reasonable basis to be pulling somebody over when this is something, as Justice Gaziano said, that is so commonplace and so many people are engaging in all the time. I don't think we want a situation in which officers are picking the driver and then waiting for the violation. That's exactly what I think is going to exacerbate the problems that you identified in Buckley, that Justice Budd's concurrence identified in Buckley. I don't think we want to exacerbate a problem that we know exists. I think, if anything, we'd like to try to mitigate it by construing ambiguous traffic laws in favor of the driver. And that's what I think this is. This is an ambiguous traffic law that should be construed in favor of the driver in this case, and consistent with the legislative intent to avoid absurdity and to avoid exacerbating pre-existing consequences that can arise.
Why is it not a perfectly reasonable and sensible interpretation of the statute to say the first provision shall so drive that the vehicle shall be entirely within a single lane, means that if I decide in a 2-lane road that I'm going to straddle both, I'm going to drive basically between those 2 lanes, that even if there's no one else on the road, they can pull me over if I'm doing it for any meaningful period of time. You can't occupy 2 lanes. You have to occupy 1 lane.
Right.
So if you're straddling it for a substantial period of time, that's illegal.
If
Do you
by
agree?
straddle you mean going over,
I mean, just literally.
it's in the middle. You're in the middle of the road.
Isn't that sort of what the first provision says you can't do? You can't basically use both lanes. You have to use 1 lane.
I think that could be a fair construction, and I think that would be something, obviously, that Mr. Larose didn't come remotely close to doing.
Right, I understand. And if you're going to change lanes, which you can do, you have to be safe in doing so.
I think that's right, but I wouldn't just restrict the third clause to changing lanes. I would also include it in things like what happened in this case,
Oh, okay.
a
So
kind
if
of
you're going to be
fleeting
avoiding
lane
a deer,
deviation.
or if you're going to be moving over because there's a car that's moving on the left lane towards yours, you may want to move into the other area.
Partially
to give
into the other
yourself some-
lane and then return to yours. But I do think the third clause shouldn't just be limited to lane changes. I think it also should, I don't think it's so clear, as the Commonwealth suggests, that that move from means only changing lanes and not the sort of fleeting lane deviations that can occur for any number of reasons.
Because there could be times when it's snowy and slick, and that if you were actually to not do that, it may be more dangerous to move onto your lane.
That's right, and that's the point I made in my brief. Really is the absurdity point. There can be so many times when it can be safer to deviate across the lane lines than to maintain perfect lane compliance. So I would urge the court.
But doesn't that come, I mean, I know that your client ends up getting prosecuted for drunk driving, but we're usually dealing with people being pulled over for lane violations, and then you tell the officer, well, there was a pothole in there, or, you know, I was avoiding the dead, you know, rodent. You know, I mean, the police officers, you know, can apply this sensibly, can't they?
Well, I don't.
So it's not absurd, it's not absurd when you realize that there's going to be a conversation that follows that.
I don't think, so I think the premise of your question is accepting the Commonwealth's reading and then kind of conferring discretion on officers to avoid the
I
absurdity.
mean, I actually read it the exact same way the chief just described it, which is that you're supposed to stay in your lane, and when you change lanes, you're supposed to do it safely.
Well-
I don't find that very bizarre, I actually find that completely sensible.
Well, I think we can't just confer on officer discretion kind of the ability to avoid absurdity when it would actually be a technical violation. I mean, by that reading, it would actually be a technical violation of this.
Not necessarily. I mean, you could also read you don't have to stay in your lane if you're avoiding a dead deer, but you tell the officer that. The officer will also see the dead deer as he drives or she drives by it, right?
We can't resort to officer discretion to craft atextual exceptions to statutes,
That's
Justice
just
Caster.
not, you're talking about a lane violation, and can they pull you over for, you know, because they see you've had a lane violation, but then you can explain why you did it. Now, if it's, well, I was texting while I was doing it, that's gonna be that's not gonna be a defense, right?
Well, this court has repeatedly said that traffic stops they're constitutional seizures. They can be humiliating and frightening for the occupants of cars. I don't think we want to allow someone to be pulled over for avoiding a dead deer, and then they can explain to the officer that there was a dead deer in the road and they were trying to avoid.
We don't have the dead deer case, though.
sorry?
We don't have the dead deer. We actually have 1-1000, 2-1000, 3-1000. He's crossed over the line, right?
That's right.
That's not a momentary blip. And I watched the video too. And it's a very tight road that
Yes.
they're on.
Yes, it is. And I guess my point is, I don't see a way, if you're going to read the statute as you just suggested, to avoid the absurdity. I really don't, because there would be no textual basis for the exception for the dead deer, just as there would be no textual basis for the exception for the sort of fleeting violation that
What do
occurred
you do with
here.
Justice Gaziano's question? Why wouldn't it be just as absurd to be pulling people over for 56 miles an hour in a 55-mile-an-hour zone?
Yeah.
I mean, to me, that seems just as absurd than one isolated dip over the fog line.
Well, I mean, then if someone challenges the speeding statute, then you could find that to be an absurd reading. But that is what the speeding statute quite clearly says. And so I think, this court has said that a canon of construction is you don't take the literal language of something if it will lead to absurd results. And I don't think it's absurd to say if someone's speeding just a couple miles over the speed limit that they can be pulled over, because that's a prima facie violation, and it's kind of a clearly posted speed limit. So it's not absurd to say someone's.
But there's no suggestion in evidence of the circumstances that the reason that he went over the fog line is because he needed, he'd made a decision, well, I can now change lanes for my safety, safely.
Well, I would say the question probably goes the other way. There's no objective evidence that he didn't ascertain that it could be done safely. And as I suggested earlier, I think in response to Justice Cypher's question, I don't think it's a coincidence that at all moments when it would be unsafe to deviate, he doesn't deviate. And when the road is completely open and he has just passed the last car and he sees no cars coming, and he's probably a little nervous because a police officer's been behind him for 40 seconds, he deviates at that moment when there's an entirely open road, no guardrail, no person walking their dog at 1 o'clock in the morning on a Saturday morning, no children on bicycles, as the Commonwealth suggests in their brief. There's nothing over there at that moment. And so I think we could easily say that there's a measure of ascertainment that's happened when a person sees a wide open road and knows that the sort of fleeting deviation that occurred here is not going to pose any safety risk to people on the road. And so, I just would leave the court with, I don't think we want to confer this sort of unbridled, unconstrained discretion on officers to just pull over almost any car on the road. I think the traffic laws should be limited to situations where, as this traffic law does seem to be on its face, to situations where there's a safety risk. I mean, the legislature knows how to write statutes that create per se violations. They did with the speeding.
So many different traffic stops. I mean, you don't have anybody around, and you don't come to the complete stop at the stop sign. And I won't keep on going on and on.
Yes.
I'm going to stop with that one example, but
that's
go on and on.
And your example's perfect, because the stop sign statute, the stop line statute, says it's a per se violation to go over that line and not stop. But I'd contrast it with the turn signal statute, which says it's only a violation of the turn signal law if you don't use your turn signal in a way that would affect another vehicle. And so I'm just saying that the legislature knows how to write statutes that create these per se very clear violations, and this isn't that. This statute is much more like the turn signal statute, and that's exactly what, again, in Crooks, the Supreme Court of Florida, they looked to their other statutes, including in that jurisdiction, the turn signal statute, and said, this statute seems to be more like the turn signal statute, and so we're not going to call it a per se violation the way the state wanted in that case. So that's the exact contrast that I tried to draw in my brief between statutes that create these clear, unambiguous per se violations and statutes that don't, and I would submit that Section 4A is a statute that doesn't. And if there are no further questions, I would rest on my brief.
Thank you.
Thank you.
Mr. Townsend.
May it please the Court, Thomas Townsend for the Commonwealth. Section 4A includes two separate clauses. The first clause having to do when you're driving must be entirely within a lane. The second clause is when you are moving from the lane. It must be done consciously and after first ascertaining that it is safe to do so. So in the dead deer hypothetical, under Clause 2, you can drive around the deer, but you can't just swerve into the oncoming lane without first ascertaining that it's safe to do so. So the typical driving, which in this case the defendant was doing, you need to stay within the lane. Now, we know he did not, or there is indication that he did not consciously and purposefully drift over the fog line, because there was no apparent reason to do so. He didn't put on his blinker to do so. If he had thought that the officer was pulling him over erroneously at that point, he could have turned on the blinker, pulled over to the side of the road. That would have been under Clause 2. That did not happen. He drifted over the fog line for 3 seconds and then righted himself back into the travel lane.
So which do you say he did, Clause 1 or Clause 2?
It's Clause 1. He was driving, and he did not stay within the lanes. Now,
So if somebody thinks they're going to turn, move to a different lane, and then looks and says, better not do it, it's a violation of Clause 1? If you sort of move slowly into a different lane,
Right.
and then say, oops, that car's coming on pretty fast, I'm going to go back, that's a violation of Clause 1?
That's not a violation of 1, because you were consciously, you first ascertained whether it was safe to do so. You started moving out of the lane. You see that it's not, in fact, safe to do so. You move back into your lane. So that was movement under Clause 2 after first ascertaining the safety of doing so.
But how do you know that that Mr. Larose, the movement, there was nothing, I mean, I've seen the video too, there's no indication anything about it was unsafe.
Well, that's only if you collapse the first clause with the second. If you read a safety clause into the first one.
Okay, I'm not necessarily, but I view the first one to be substantial straddling, the older man, and I'm getting there myself, who sort of decides that the best way to be safe is to drive right in those two lanes, and you're driving along those two lanes, because that gives you the most room on either side.
Well,
I understand that, but that's not what he did.
right, but that's still a violation of the plain language of the first clause, which requires a motorist to drive entirely within the lane.
So any momentary, a quarter-second departure, if you cross that lane for a quarter-second, that's enough?
If it wasn't done consciously and after first ascertaining the safety
But that's
of it.
clause 2. You're saying you're relying on clause 1. That's where I'm confused.
Well, if the defendant intentionally and has a reason to go over the lane, wants to make way for an emergency vehicle with lights flaring and sirens, that would be an intentional movement under clause 2. There's a world of activity on the other side of the fog line. There could be bikers, pedestrians, joggers.
But there weren't here.
There wasn't. Thankfully, there wasn't.
Well, but I mean, there's not, so doesn't that matter?
It does matter. It's not a no harm, no foul. The only indication from the video is that it was inattention or carelessness or inebriation that caused him to go over.
Does it also matter that there was no 7-Eleven or any place where he was turning into on the right?
Well, if there was a driveway or a parking lot, and presumably if he had turned on his
Probably
blinker.
too young to remember Mr. Magoo, right?
I remember Mr. McGill.
Okay. No analogies, Chief.
But if he had put on his blinker signaling that, and if he had thought, oh, this isn't my driveway, I want the next one down, he could go back into the lane after ascertaining that it's safe to do so.
Is the chief's hypothetical, though, too strong? I mean, if, you don't need to be going 80 for the cops to pull you over, right? You don't-
Correct. 1 mile an hour above the speed limit.
So isn't this the same? The cops have the ability to pull you over, as Justice Gaziano says, at 58.
I believe it is a bright line rule, literally.
So it really is the same. You don't need to be driving 80 or 75 for them to pull you over, nor do you need to be halfway over both lanes to be pulled over.
Right. Any crossing of the fog line is a violation of the first clause, unless it was an intentional movement under the second clause and it was done after first ascertaining that it was safe to do so.
What do you do with the point, though, that you follow somebody long enough in a car that that they're going to drift over the fog line at some point, and it's an enormous amount of discretion to give police officers?
Well, police officers have that discretion with speeding. I submit many more people speed than they drift over the fog line.
Or when you put on the signal, I understand all that, but what do you do with that? What do we do?
Well,
with
if there is a discriminatory basis to challenge it, there's a framework that this court has applied in Commonwealth versus Laura, where statistical analyses and a motion to dismiss can be predicated upon that. But there's no indication of that here. There was never raised below that this was a Laura motion. This was a plain motion to suppress based on unreasonable stop. It's just reasonable suspicion that the Commonwealth needs to satisfy in this, and going over the bright line and violating that rule violates Clause 1 of the statute. Other courts have grappled with these issues, and I particularly like the New Jersey Supreme Court's analysis of this issue. And the New Jersey Supreme Court in Regis, very similar statute, where it's broken up into two clauses, said, well, there are two problems with the defendant's interpretation in that one. The first clause would be subsumed by the second. If all it prohibits is unsafe violations of the line, then the first clause is a nullity, which requires driving within the line. And secondly, and this is the absurd aspect from the defendant's argument, if it only requires unsafe breaches of the line, then if there's no other traffic, a motorist could drive back and forth over the line, or just ride the rumble strip over the fog line, and that wouldn't be a violation of the statute. Well, that's clearly a violation of the statute. And so I urge this court not to collapse the two clauses. I think the clauses are separate. There's a comma, there's the word and, there's two different shalls. Shall drive entirely within the lane, shall not move from the lane unless first ascertaining that it's safe to do so.
But
I think it's very clear.
You agree that no one can drive entirely within a lane, because you would never get there.
Right, if you do need to,
You have to, at some point, get off the road.
correct, and that's, and the New Jersey Court and Regis spoke to that. Also, the Tennessee decision's very good. It approaches the issue from every perceivable angle. Obviously, you can turn, and that's the second clause. You can move from the lane after first ascertaining that it's safe to do so.
And if it turns out that there's snow on one side of the road because of the way that the road's been plowed, and that it's a little bit safer to be, if you're touching the lane marker, is that being out of your lane?
Well, the courts, frankly, are split on that, whether touching or it must go over. This case doesn't present that issue. An argument can be made, and I think the court that most recently, or the jurisdiction that most recently addressed it was Minnesota last year, and they found that the fog line is no different than the center yellow line. We don't want people driving on the center yellow line. We don't want people driving on the fog line. So touching the line would be a violation. That issue is not before this court. This was clearly an entire breach of the fog line.
So anytime anybody who is not seeking affirmatively to change lanes or make a turn goes over the line even for an instant, that's a violation.
If it wasn't done consciously and after first determining that it was safe to do so, yes, it would be. Drifting over the fog line
You
is
have a
not.
police officer following a car. So how is the police officer to be ascertaining the consciousness of the individual when the person makes a stop?
Well, if no directional is activated, that's some indication that it was not conscious movement of the car. If there's no obvious reason to move, if there's, the dead animal in the road was a good example, the officer would see the dead animal. And even if someone were to go around it, directional is a good idea. Slowing down is a good idea. There was no obvious deceleration in this case. There was no directional activated in this case. There was no obvious reason. There was no parking lot. Unclear whether there was a driveway there, but he did not turn into the driveway. And there was no mailbox adjacent to the driveway. There are mailboxes elsewhere in the video. So that's all indications that this was not a conscious swerving. And there's trees, obviously, lining the highway, and presumably houses set back. And so there was no obvious reason to swerve over the fog line. And he pulled, as he was entitled to, he pulled over the defendant. If the defendant wanted to say or give a reason why this is a Clause 2 case and not a Clause 1 case, he could have.
Exactly. No one can drive, I mean, maybe with your automatic thing, you can drive 55, but no one can drive steadily at 55. You're going to be at 56 sometimes and 54 sometimes. But I guess they can pull you over, right?
I sped my whole way here on the Mass Pike until I hit Framingham. I could have been pulled over.
55 the whole way. Or you wouldn't be here.
Right. Well, it's up until Framingham, and then no one's going over 55. But every other car was going, or 65, I guess. Every other car was going over 65. And like my brother, ever since having this case, I'm very conscious of the fog line. I saw one person cross the fog line my 2-hour commute here today. So I don't think it's as widespread. But again, this is a matter of statutory construction, and the line has been drawn, so to speak, and by crossing over the line, it was de minimis, yes, but in this case, it did get a drunk driver off the road.
But this applies not only to the fog lane, this applies even to a 3-lane highway, to any momentary, even if there's no one else on the road, any momentary movement to a different lane to go back is enough.
It has to, no, because everyone is entitled to move, a multi-lane highway, you're going back and forth all the time. But you have to ascertain that it's safe to do so. If there's a car in your blind spot, just go over without checking it, well, that is a violation.
What if there's no cars on the road? You're going back late night, going back to Hampshire County, there's no one else on the road.
Still, you have to ascertain that it's safe, especially with the fog line where,
But here, there's no question it was safe.
but there was no ascertainment ahead of the veering, is the point. The motorist has to ascertain first that it's safe to move from, in the words of the statute, move from the lane.
But
Other-
there was no indication that the officer could possibly have seen, if you look at, that there was anything unsafe about what he did.
I'm not saying it was unsafe. I'm saying this is a Clause 1 violation, which doesn't require it to be unsafe. Just as going 1 mile an hour over the speed limit need not be unsafe. This is, the second clause is separate for moving from the lane. It must be done safely.
But it
And
was done safely.
it must be done.
But it was done safely, right?
It ended up being safe because there was no one there.
Right.
There's no indication that the defendant here consciously went over the fog line.
But then you're trying to get into the driver's head again.
Well, I think under the second clause, I mean, it could be objective or it could be subjective.
But there was no purpose for which he was legitimately crossing the fog line in this case, as opposed to someone on a 3-lane highway that may want to slow down, speed up, and travel across the 3 lanes, right?
There was no apparent purpose for it, and there was no signal given.
It's
But
also,
under
it's
the,
also 3 seconds. I mean, it wasn't a blip. 3 seconds in a car is, how much, I mean, I don't know how far he went, but it wasn't just a brief slippage over the line. He was over the line. I watched it. He was over the line for 3 seconds.
3 seconds sounds brief, but seeing it on video, it's substantial. And it was a substantial deviation, and using different tools on the computer, it was 3 to 4 seconds. The motion judge said it was 2 to 3 seconds. That was not accurate. And it was substantial, and but even a momentary crossing would violate that bright line rule. But this was enough for the officer, in his discretion, I know there's discretion, to pull him over for that violation, just as the officer would have discretion to pull someone over who's traveling 66 and 65 mile an hour zone.
Now, what do we do with the fact that the judge found that the police officer was not credible, and indeed was not credible in his description?
Right, apparently the officer was mistaken when he testified, but we have the video. And the video, this court can review independently, and the video clearly shows that there was a violation of the first clause of Section 4A. Unless there's further inquiry from the court, I'm willing to rest of my brief.
All right, thank you.
Thank you.